Hey, everybody, welcome back to Jury Trial Mentor. My name is John. I'm your host. I'm talking to my brother Carl, the experienced criminal trial attorney, and we're going to talk today about the Dan Markel murder, specifically the case coming up against Charlie Adelson, and also what we hope to be the future case against his sister, Wendi Adelson. So, Carl, right, right off the gate, I want to talk to you about the upcoming trial of Charlie. What are the odds that Wendy will return for trial 3 that she'll be testifying in? Is there a chance that she'll be pulled up again and to testify against her own brother, or how's that going to work, do you think?
Yeah, I've seen that on a number of YouTube channels where folks talking about how Wendy is going to be testifying against Charlie, and that's maybe one of the reasons why they haven't charged her yet. But I don't see that happening at all, and I don't think she's going to be wanting to testify. Number one, so if she gets a subpoena, I would expect that she's just going to say, "I'm going to plead the fifth," and if she's going to plead the fifth on everything, then the state will be in a position where they don't call her. So there's a general rule across American jurisprudence where if somebody's going to invoke their Fifth Amendment rights, you don't wind up calling them as a witness at all. So that's what I expect to happen here for Wendy's case, because she's not going to be willing to testify and put damage on her own brother. When if you stop think about it, she's right now 2 for 2. At least one person's been convicted every time she testifies. So for that reason, I don't foresee her and predict she'll testify at all.
She's lied so many times and she's changed her testimony from KD1 to KD2. Why do you think the prosecution hasn't, or at least hasn't yet, gone after her for perjury? Because those are some pretty big flip flops, especially when she changes her testimony about driving to the scene of the crime for the crime scene inspection.
Well, if they want to do that, they have two different trials. So the last one happened like a year ago, and the one before that happened 3 years ago now. So I believe there's generally across the United States a 5-year statute of limitations. So I would expect them to bring those kind of charges when they actually bring the murder and conspiracy to commit murder charges against her.
When, as we both believe that Wendy is indicted, what are the odds do you think? What odds do you give Wendy actually testifying on her own behalf in front of a jury?
I don't foresee that happening at all because she's done such a terrible job so far. It would be very easy to cross-examine her. And the thing is, for a defendant, the jury holds such a heightened standard of review for them compared to every other witness. And if you have one little thing you say wrong, it can be the end of your case. And so there shouldn't be a different standard for a defendant on a murder case versus any other witnesses. But there's really, from my experience, and for any defendant in a criminal case for that matter, there's such a heightened scrutiny that the jurors will use for that person. And if they find one little thing wrong, that can, like I say, that can be game over for the defense. So that's why defense attorneys really resist having to put their client on the stand. Ultimately, under American jurisprudence, that is the defendant's call when they want to testify or not, but they're going to rely and should rely heavily on their defense lawyer. But a lot of times you can have clients that don't want to listen to that advice and will
Mhm.
decide to take the stand anyway, but to their own detriment. I mean, if you look at the Murdo case, that pretty much sealed the deal for him. He came across terrible and just absolutely just was destroyed on cross examination. So the same kind of thing I would foresee based on what I've seen from Wendy's testimony so far.
What about Charlie, though? Do you think the maestro has a better chance of saving his own bacon when he gets on the stand?
Well, I don't think there's any way you can talk around his involvement and have any credible sense from what I've seen of the information that we have from the Dolce Vita tape, and also from what we've seen from some of the other testimony of how he was stapling the $100 bills, and also it's going to come out that he's willing to put a hit out on someone to keep him silent. The guy who put the bump on his mother. So those are the kind of things you just cannot talk your way out of. I know that when Rashbaum talked to Tim Jansen, Tim said there was a couple, interesting theories on his defense, but I just don't foresee anything that's credible that a jury's gonna be confused by and find reasonable doubt.
No, Charlie's attorney Rashbaum was up in Tallahassee not too long ago, speaking to attorney Tim Jansen. That was spoken to on your last Surviving the Survivor interview. What's your take on that? What do you think? Is that a good thing? Is that basically Rashbaum being a good advocate for Charlie and getting the scene up there in Tallahassee? Or what's your take on that?
Well, I think it's a good thing to do that, to try to find the legal landscape that you're about to be taking a big case in. I mean, there's not a bigger case as a criminal defense attorney than a murder case, unless it was a capital murder case, obviously. But this is right up there with that, and so you got someone's life in your hands. So you need to find out as much you can about the culture, because, from my experience, every every place across the United States has a different culture. So even like, say, in Texas, the culture is different in the Dallas Fort Worth area compared to San Antonio, compared to Houston. And you really have a disadvantage if you don't really know that culture as an attorney. So having local attorney as co-counsel is the ideal. And if you don't have that as an option, then the next best option, I think, is to do some investigating and interview people and find out what's the landscape about, what the judges like, what the juries are like, what the demographics of the jury will be, and what they tend to convict, and what they tend to acquit on. So those are all the kind of things that a very seasoned attorney is going to be looking at.
Yeah, that's a very good point. I mean, you look at western or west of Tallahassee, that's a totally different demographic than the city of Tallahassee, and which is probably different from the eastern part of that county. So, so basically,
Right.
you're giving him props for doing that. Man, Charlie's legal bills must be skyrocketing, because we also found out that Rashbaum traveled to New York for a deposition, at least one. Um, what's your take on that? And do you think right now the depositions are gathering steam now that the summer is here? Because I actually thought the whole court system was pushing things back to allow summer vacations to happen and stuff like that. So, what do you read into that? What's going on? And do you think Rashbaum is pretty busy with depositions between now and November?
Well, I don't have boots on the ground to know what their deposition rate is. I was curious as to why that wasn't represented in their motion for continuance, or why it wasn't brought up by the judge. It's like, wow, what percent are you complete in preparing for this case? There was never any percentage, or a number of witnesses, or a number of pages to review, that kind of thing. But there was representation would be ready within 2 more months. So for him going up to do a deposition in New York, that's probably par for the course as well. You want to try to interview all key witnesses, and witnesses that may not be key, but just to do your due diligence, you need to try to unturn every stone, and go beyond what's in the police report. If you're a prosecutor as well as a defense attorney, I never look at the police report as like the starting and end point of what I need to do to win a case. I'm going to take it way beyond that.
Switching gears a little bit, how do you think Charlie's relationship with Wendy is today? Because I'm taking it they're not able to speak very much, and if they are able to speak, or they are speaking, being that she's an unindicted co-conspirator, that conversation will be monitored by the police, correct?
Well, because she's not charged, it's actually they can talk, but it would be monitored. But from what we've seen from True Lifestyles, there's been zero conversation the entire time, the year plus now that Charlie's been in confinement, that he hasn't talked to his sister at all. So, is it possible that maybe there's a three-way call, and she's on the phone that way or something? Perhaps, but I think that I think there's some um, I think there's some dissension there going on between the two, and I think Wendy probably looks at her brother as being a nuclear hazard, and she doesn't want to have anything to do with him.
Hmm.
And I think from on Charlie's side of it as well, I'm not sure if he was thrown under the bus like that intentionally, and he was aware that that was part of their plan or not. I think that very well could have been part of their plan. Hey, just point it down here that, it could have been me, it could have been your parents, just to throw all these confusion bombs to the police. And that way they won't, even if they think it's an Adelson, they won't know which one did it. And that's reasonable doubt right there. So Charlie could have came up with a scheme like that to have Wendy follow. But ultimately, these kind of things are not gonna work in the end if they actually do wind up charging Wendy, which I expect they'll do here in the near future.
Carl, what is the key or keys to the many trials that you've won over the years? Can you share the audience your thoughts?
Well, it's a consistent thing. What I find with my opposing counsel is that they're not prepared on the facts or the law. And so if I have the upper hand on both those, I go into the courtroom pretty much expecting to win. And that's normally the case because if you don't know the facts, then you don't know the good facts and the bad facts to your case. And so I can stay away from the bad facts that are on my side. And a lot of times the other opposing counsel will not even be aware of those. And so I don't want to necessarily tip my hand that I know there's some bad facts out there, like in my opening statement, because I did that when I was more of a junior prosecutor in our defense counsel, let's say, and the other sides were not even tracking that, and so I realized that um, having that superior preparation than your opponent is going to be such a great advantage. And so don't necessarily assume that they're gonna be on an equal footing with you in preparation. And so then also understanding the law and being able to anticipate what they're going to throw up in as roadblocks. A lot of times prosecutors they'll try to object to your line of questioning just to try to throw you off, just to try to cause their own little confusion bomb as well. But you just got to maintain your footing and keep going at it, and keep destroying the government's witnesses that are against you through your cross examination and superior preparation. And if you got the facts on your side, I think that's the real key. I don't ever want to go to trial if I don't think I'm on the winning, actually on the winning side, um, just not the fact that I'm able to throw confusion bombs and create reasonable doubt. I like to know that I'm actually on that have truth on my side for my client and our cause. So with that having the benchmark of success, I think it really puts a lot of pressure on the attorney. If you know your client's innocent, let's say, or if you're the prosecutor and you know the defendant's guilty and you have no doubts whatsoever about that. I mean, it's in a way it actually puts pressure on you to have to not be the cause of the failure for that. But if you really know what you're doing and you know that, like I say, the facts and the law, and you have the experience and you've done this enough times, you know, and can predict the outcome, then you're gonna be good at it, and have the expected outcome. What I don't like hearing attorneys saying is like, "Well, you'll never know what a jury's gonna do." I just cringe when I hear that because that's something I look at as someone that's not as competent or experienced in themselves. Because if you do have that experience, you can pretty much predict what a jury's going to do, especially if you've been working that locality, that particular part of this of whatever state you're practicing in. You should know the kind of stuff that how that culture looks at things based on how you present it.
But Carl, there's always those people out there that say, "Yeah, but look at this exception. Look at the, let's say, Casey Anthony trial," or they'll pull up another trial where people that pretty much everyone agreed was guilty got off. Those are just wild exceptions. You can't go on that, right? Those are exceptions to the rule.
Yeah, there's always exceptions. There's not going to be 100% across the board every single time that somebody that's guilty gets convicted, and someone that's innocent gets acquitted. I mean, you have aberrations like that, but to say that that's a reason not to charge or not to go forward on a case like this with Wendy, I don't look at that as a legitimate excuse.
With Charlie's upcoming trial, how much evidence compared to normal trials, I guess, is a good way of asking it, perhaps, does the government have against Charlie? It seems to me like there's just a ton of evidence, but I'm not a lawyer. What say you, Carl?
Well, they have, and I've said this several times before, the videotape is what's inexplainable. The defense counsel argue, well, he said in there that, we got nothing to hide. He said that numerous times, numerous ways, but that's what guilty people do when they think they're possibly being tape recorded by law enforcement. So for him to say that, it doesn't mean anything. It just shows he was actually like a cornered rat and trying to. He was in a panic mode, and if he stopped to think about it, he was the plan he thought had worked for 2 years, and all of a sudden the hitmen get arrested, and that really threw a wrench in him. But then I'm sure he was telling his family, "Oh, don't worry. You know, they're never going to figure out it was us. We got a firewall with Katie. They're never going to realize that Katie's not going to flip on any Adelsons." So, and they're pretty much right on that for a while, but they didn't expect the bump, and the bump was what threw the wrench in everything. And that's the kind of thing that's going to remove any doubt, because if you look at the other evidence against him that's strong in and of itself in its own right is the who came up with $100,000 that the hitman and Katie split among themselves. $100,000 in cash. I mean, that's like an
Stapled
unheard of
cash.
amount. Yeah, it's stapled cash, exactly. And how many times have you heard of hitmen paying that much? Normally, when you watch all these crime shows, it's like not even a third of that. So for somebody to come up with $100,000 to non-professional hitmen at that, even it just goes to show the degree of planning and hatred of Dan Markel. So who's the one that hated him the most? That pretty much is going to answer who done it. So, in Charlie's particular case as well, um, Katie would have not done this on her own behalf, and maybe his own defense counsel. That's one of the strategies that defense counsel are going to do in a case like this. Is I would expect is to point the finger at somebody else. I think you're always on more of a weak footing and less credible footing. If I have someone that's if we have a known victim of a crime, and the defense attorney is merely just saying, well, it's not my client, and it's somebody else that did it, but it's not my client. So that's not as persuasive and convincing to a jury as if you actually have the ability to point the finger and present evidence showing how it was a particular party that you're saying is the one that should be in the defendant's chair.
Do you think that Charlie might point his finger at Wendy in his upcoming trial?
Well, see, it's the attorney that has that decision, not Charlie. So the defendant doesn't have a choice on strategy. The defendant has a choice on whether they want to plead guilty or not, whether they testify or not, both on the merits and on sentencing. And so everything else on strategy, tactics, and everything like that, ultimately it's attorney's call. So, the defendant is not the one to know the best way to win the case, although they may think they know it.
Well,
They,
Carl, we are talking
they don't.
about the maestro.
Yeah, well, it's not going to work out well if a seasoned attorney takes trial tactics and strategies, and all that advice from the maestro. I mean, look, he's the one that got all these people behind bars to begin with, based on following his advice on how this is the perfect murder in essence.
It's so fascinating. Even Harvey was deferring to Charlie and listening to Charlie speak. That was captured, of course, in the Matsuri sushi restaurant in Florida with his dad talking to Harvey. Talking about that real quick, when I listened / watched that, it didn't really seem like Harvey's really implicated in anything other than the fact that he clearly knew after the murder what's going on.
Yeah, I would agree with that assessment. I would say him giving the vehicle to Katie. It was an older Lexus 460 series, I think it was 1992. So it was like almost 20 years old. It was maybe worth 5,000 or something like that. So it wasn't like a new fancy car. But I think part of that also was by design, is that they didn't want Katie and the others flashing, brand new cars with their $30,000 and whatnot. So it would have been too obvious. So I think they were trying
Mm.
to be more on the down low, keep her quiet. And I think that's the real struggle. It's like, well, what do you do to entice her to stay quiet if she's been arrested? And so I think that's what there was probably some promises of continued dividends if she got acquitted, or another hung jury, or things of that nature, because it's just baffling how she would not have offered up testimony to reduce her sentence.
Charlie must have been really frazzled and rattled because when you watch that tape, he actually at one point looks at the bag that the FBI camera is in and mentions it. So he
Yeah,
must have been really paranoid.
he's totally in panic mode at that time because he's he can't figure out who did the bump, and now without being able to figure out who did the bump, it's this to think about it. Your whole plan could be unraveling right before your very eyes, and in fact, it was. And so all of his big tough talk and I know it all and all that kind of stuff. Um, Even if you remember, even Harvey's asking him about, can they record that? You know, when he was looking over at the recording in that kind of bag. So
Not
anyway,
without a
he was
warrant.
still he was still deferring to Charlie's expertise in how law enforcement works. So how, which begs the question: how would a dentist know anything about law enforcement murder investigation tactics? So it's pretty telling. But I would say, yeah, in terms of Harvey, that they don't have as much evidence there. But obviously, he did not say anything to the effect of "you messed this up. I told you not to do this." So it's just so obvious right there that he was aware of what was going on and had sat in on the planning. And maybe even gave some direction as well, but that's why it'd be helpful to get some of that evidence out if more people are charged and are willing to flip.
Yeah, and that's the cool thing about the proffer is, yeah, we're a little bit disappointed about the length of it. It's about 5 hours, or maybe it was 4, but we don't know what she said, and she can speak a lot in 1 hour of time, let alone 2, 3, 4, 5. And who knows what she said about everyone, including Harvey. Correct?
Right. I would. I mean, I was very disappointed to see it was only 4 hours over, but they did come back more than one time. So maybe there was some a golden nugget there, a real dagger against any one of the Adelsons that was worthwhile. Maybe she told them where to find certain evidence, or maybe had certain things on tape recordings that she had preserved. But um, I I don't know if she was had that kind of foresight to keep her keep evidence on the Adelsons in her back pocket in case things went south on her. I think she was so enamored with Charlie that she thought and believed whatever Charlie said was going to be the absolute truth, which is they're going to get away with this. So that's why I think she didn't have that kind of detailed, concrete evidence. But one of the things I do think that's favorable to looking like she may be having some evidence that's worthy to bring forward in Charlie's and other Adelson cases is the fact that they held her up there in Tallahassee so long. So normally having her there, what I think it was like almost 4 months. That's a good sign that she wasn't just so weak that they just thought we're only going to see you one time and we're going to send you back to the state prison. Because from what I've seen, normally if someone's being brought back from Department of Corrections, which is under state control, back to the county system there. Sometimes there can be issues of who's paying the bill for that person. That's there in the local jail. So if it's a county jail, then the state has to be paying the county that extra money. So it's actually more burdensome financially for the state to be keeping them there. So that could be a reason why they really would want to get them sent back to the state pen if they were not being fruitful with other evidence of co-conspirators.
Now, Sigfredo Garcia, he basically was in the same position as Katie, meaning both convicted. She's talking, or she spoke already in the proffers. What about him? Is there a possibility he could still decide to change his tune and testify against the rest of the Adelson clan?
Right. I mean, that's something I'm sure his appellate lawyers are probably talking to him about. It's like, what can you offer to the state's evidence to try to get your sentence reduced? That would be the easiest thing to get his life sentence reduced. But how much detail does he know about the other Adelsons since there was that firewall? Not sure, but obviously Katie would be able to tell those details as well and do some corroboration. So maybe they'd want to use the both of them. And I've not seen any reports that he's been there at all, like Katie was. We heard reports of that. and there was an order to transfer her back to Tallahassee. So that was on file there. So I don't know if folks are checking any filings for his case, but it's probably because his case is already over. He's convicted. Those kind of things probably wouldn't be filed at all. It would just be more like a memo from the state attorney's office to the Department of Corrections saying bring this person back. So you'd probably find him on the jail logs as being housed there for a period of time. So don't know if anybody's looked for that, but that'd be one way to find out if he's also doing the same thing like they used Katie for.
Jumping back real quick to the Matsuri meeting between Charlie and his dad, Harvey, it kind of baffled me how rudimentary and how plain Jane the technology is that the FBI / prosecutors were using to spy on him. I mean, it just seemed like basically a camera they threw into a bag and just hit the record button. Is this typical in high profile investigations like this, that they don't have better equipment?
Well, I thought it was very sophisticated for them to do a bump. I mean, I thought that was a great thing to do because it wound up being like the key evidence you need to get a slam dunk against Charlie, and so as well as his mom, right? So the thing is though, why it was such a poor quality tape and why you'd have to see through the holes of the bag, and so you'd think there'd be some kind of you know a little pin mic, or they have buttons and stuff like that. I mean, you're talking about really old technology that they use. So yeah, I was shocked to see that. But from my experience, actually, the federal law enforcement, including military law enforcement, they're way behind the times on actually recording events as they happen, to include interviews or interrogations in the law enforcement centers. For example, that was a great thing that Tallahassee Police Department has at their disposal, is having all the interviews on tape, not just audio tape, but they actually have live video feed recordings. Think of the loss of evidentiary value on so many witnesses in this case, especially people like Wendy, right? Wendy in there for as many hours as she is. There's so many different things you can glean from that to indicate that she had awareness and was part of the planning, and her mannerisms were just not credible at all from my experience. And so but from what I've also seen in federal practice is even federal judges get angry when there's motions to suppress. They're accusing law enforcement of doing certain things, and there was never a recording like they had in the Tallahassee Police Department. And the federal judge actually, that one that I practiced in front of, said that you will not have any interviews without a video camera present, and if you don't record it, and there's a motion to suppress, I'm going to presume there was something or some bad faith on the part of the government. So that's how bad it is not to have the camera. That the judges are even frustrated that you don't have that kind of evidence to fight the litigation. Because if you have a videotape, it's the video speaks for itself, right? You don't have a swearing match. So years ago, before you had videotape testimony, it would just be swearing match between the interviewer, detective, and the defendant accused. So with that, there was always well, what's the truth kind of thing, and the judges were left to figure it out. Now that we got videotape, there's a lot less motions like that because the evidence just speaks for itself. So yeah, I would say also the fact that they didn't have the enhancement done internally, but the FBI, that Georgia had to go find some mom and pop private videographer to do the enhancement was pretty shocking. So I mean, there's plenty of agencies within the federal government that could have been resourced. The FBI didn't have that, but I just was I was disappointed to see that because, as you know, it took extra years to get the Adelsons to justice.
I keep thinking about the Murdaugh trial and how impressive it was the way the prosecution laid out the case in their opening and their closing. Specifically, they had all this detail, but they laid it out in nice PowerPoint presentations, so where they didn't have to talk about all the little minutia details, but the jurors could actually read that for themselves. What's your experience with laying out a case like this, which, right now they're going after Charlie. I believe, as you do, that they're going to eventually go after Donna and Wendy as well. What do you think is the best way to get across to a jury a case like this that has just so many details, big and small?
Yeah, that is true. The little details do make a big difference. And that's actually the key why I think I've been able to beat my opponents so many times is that the little details they omit, they never look for them, they don't know about them. And then either I avoid them in court or I bring them out in court and present that as the totality of the evidence to show why the jury should do what I'm advocating. And so the real key is absolutely in the details.
Yeah, and there's so many in this case. I'm hoping that the prosecution looks at the Murdaugh prosecution team, both the opener and the closer, because it was just so great the way they laid out all the details, but they didn't necessarily talk about each one. You could see it though; it was on the slide.
Right.
So they would go
Right.
over more of the bigger bullet points, and the smaller bullets, the supporting bullets, let's call them, were below that. So they didn't read through those, but to me watching, I'm like, well, they're just making a really good case. Man, there are a ton of details, but they spared us reading every single one.
Right. I mean, if you read every single little piece of evidence out there, that could help you, but it's sort of like you're reading the script. The jury's going to have their eyes glazed over. They're going to sort of tune you out. They're going to be distracted. I mean, even today with all the people addicted to their phones and stuff, they don't have a lot of attention span. So you really need to keep it moving and presenting evidence in a digestible format is very key. And especially if you got the detailed evidence that you need to, especially prove a circumstantial case, you need to put it in the right format because you could even talk it through. But if you talk it and read from a script, it's just it's you're not gonna. I mean, you could lose a case from that alone.
Yeah, I once remember seeing a defense attorney read from the script, and he lost me because now he comes across as somebody who's not really invested in his own case. And the fact that he has to read a script and is not speaking from the heart, uh, really, I think didn't do his client any favors.
Right.
So, all right, we're gonna wrap it up here,
Well,
Carl. Thanks for joining me.
I'll say this though, if
Mhm.
when I see somebody reading from a script, I uh I presume they're not prepared and I'm just ready to crush them at that point because they do not have the knowledge right off the top of their head, like you say, arguing from the heart, and that's something that's the jury does not like to see. And so when they see somebody that knows the facts, they can talk off the top of their head. They can go through the information in the right speed, not too fast, but not too slow either. That you respect their time as jurors as well. It just unites for a winning, successful outcome.
That's right. Well, Carl, thanks for joining me today. Carl and I will be doing more videos between, excuse me, now and the time that Charlie's trial starts in a few months. So if you like what you're seeing and you like Carl's commentary, please hit the subscribe button. And we want to see your comments down below. So this is just our two opinions, mostly Carl's. But what do you guys think? Obviously, we're all in this together. We're all about justice for Dan, his two boys, and the Markel family, and finally getting some justice after all these years. So we want to see your comments below. We read each and every one. So thanks again for joining us, and we'll be back within a few weeks with some more commentary on this case. Thanks for watching.